Hey guys, I am using a weird green screen right now, so my face is doing weird stuff. So anyway, um, this is going to be day 2 of civil rights. So far we have done all of the judicial branch by way of these videos. We have started civil rights and civil liberties. The first one we did was going over the Bill of Rights, reviewing the Bill of Rights, doing scenarios about the Bill of Rights, talking a little bit about the 14th Amendment, talking Brown versus Board of Education, talking all the different groups, mainly those 3 big groups that the AMSCO book talks about: women, LGBTQ, and African Americans. Don't forget, there are other ones that exist that have had issues and still have issues. You can say the Latinx community has a whole bunch of different issues right now. A lot of them are going to be dealing with immigration. You have Native Americans that have dealt with civil rights and still deal with civil rights issues. Right now, we have a big issue concerning Asian Americans going on with this coronavirus stuff. There's a whole lot of discrimination happening against the Asian communities within the United States. So that was the last class that we did, or the last video that we did. Now we are going to move into some specifics. Now we're going to talk about the freedom of religion today. Before we start though, I am going to go through a few things, make sure you remember stuff. So always send me a remind if you would like to have a study session. Anytime that you're like, I just kind of want to talk something out with you or deal with an FRQ or something like that, please send me a remind. I will figure out a way to schedule it, okay? I do have other things that I need to do. I have a 9-year-old that needs to get 4th grade, have a 4-year-old and stuff like that. So I do have other things to do, but I will try and find a way to schedule it, okay? I'm here for you guys. The last study session had about 10 people, and it basically just questions and answers, making sure they know what's going on and stuff like that, but it can be more specific if you want it to be. Also, remember, my website is there. I'm keeping it updated, okay? I have added the Civil Rights and Civil Liberties unit up there, so it's already in the makes. Google Classroom, every single thing that is assigned and is due sometime before May 21st is on Google Classroom. I'm thinking about one more assignment after the AP test, dealing with movies and possibly having like a watch party or something like that. But other than that, every single thing is already on there, okay? So check Google Classroom. I also post these videos on Google Classroom. I post them on my website. They're posted on my YouTube, okay? So you can find them a gazillion different places. Make sure you are checking College Board's website. Don't just click on College Board and go, oh, there it is. Look at AP Classroom, check your information, things like checking your phone number, checking your, your email address to make sure you're getting your emails from College Board. Checking the COVID-19 section for students to see if there's any updates specifically for you guys, because we teachers get specific things. You guys are also getting sent specific things. There's a survey that is sent through your email from College Board. Please do it. It is helping them know what is going on as far as you guys all over the world, okay? Let's see, AP Classroom, like I said, check it. Also, AP Classroom has all of the released questions College Board released specifically for 2020 because of what's going on. Lots of helpful stuff is on AP Classroom right now. Also, the College Board study sessions, I know some of you guys are watching them religiously, and that is awesome, and some of you are taking notes, and you've talked to me about them. You've, in some of our study sessions, we've discussed some of the stuff that Ms. Hitchcock has talked about, and I appreciate that. That makes me know that you guys are getting ready for this test, and that makes me super, super happy. So make sure that you're looking at that stuff. Now we also have a new thing that's being added, which is Microsoft Teams. Now we tried one Teams meeting and it did not go well because people couldn't behave. This is how we have to have class from now on Instagram, on Twitter, on Facebook, on the website, the school website, on Remind. All of this stuff has been disseminated to you guys. Okay, so that means you're now going to have to be responsible for distance learning, and you have to use MS Teams. Okay, I have a scheduled MS Teams meeting with as many of you guys that can get to it tomorrow at 10 o'clock, so we can kind of discuss what is going to be expected before we actually have to do it, and it makes sense, and we kind of know what's going on. Okay, all right, you guys. So the required cases finished after today. Ooh. Back background's making me look weird. So that means, remember, first semester we did McCulloch versus Maryland, US versus Lopez, Citizens United versus FEC. We didn't have a whole lot to do because we had a whole lot of those foundational documents instead. Second semester, I told you guys, is going to be very heavy on these court cases. And y'all, these court cases, just because we don't have a Supreme Court comparison FRQ, these act as documents to help you in your FRQs now for your argumentative FRQ, or it could be something that they talk about within the concept analysis. So these are still very important, even though we don't have the comparison, because they can connect these to all kinds of different subjects within the entire curriculum, okay? Second semester, we had Baker versus Carr, Shaw versus Reno, that was dealing with redistricting, gerrymandering, the census, and things like that. Last class, we talked about Brown versus Board of Education concerning discrimination of African Americans and kind of what happened from Plessy versus Ferguson. There's your comparison case to Brown versus Board of Education. And y'all, that was the comparison FRQ last year. It was dealing with Brown versus Board of Education. Last unit with judicial branch, we talked about Marbury versus Madison as being the initial case that kind of set the tone for what the judicial branch actually does, which is judicial review. They interpret what is on the paper. They interpret the Constitution. And then today we're going to talk about two other ones, Engel versus Vitale and Wisconsin versus Yoder. I'm going to talk about some other comparison cases as well that can help you in, your argumentation, perhaps, if they decide to throw in. To me, that's an easy way to throw in some stuff for you guys to deal with the Supreme Court cases, is in your argumentation, have the Supreme Court cases be a part of it. And then we're almost done with the rest of them. So we only have a couple more of these videos, and in those couple more videos, we are going to deal with the rest of them, and we will have hit all 15. Now, usually in class, we go a whole lot more into these, but because the Supreme Court comparison is out, that leaves it so I can give you very specific information and not have to know the entirety of the case, okay? All right, so things you need to deal with today. Just so you know, AMSCO textbook, remember I did post the online link. It is online if you don't want to, turn pages, but it's also, you have your book, pages 237 through 338, and then flip a few over, 252 to 262. And we are going to be dealing with freedom of religion today in how the courts have dealt with it. So I suggest you guys take notes. Lots of you guys have not taken notes all year long. This is where it's important because that test, that exam is open notes, okay? You can have a giant stack of papers if you want. You can have Wikipedia open if you want. You can have, all kinds of websites open if you want. Things you can't do on the test though, you can't use human help, okay? You can't get in a chat room. You can't ask a friend. You can't, none of that. But if it's on a website and it's written down, you can use it on this test, okay? Now, I will say, and we're going to talk about this tomorrow, College Board, Trevor Packer, who is the vice president of College Board, has explained that if you rely on notes and you can't answer the question or have no idea, you're not going to do well. The people that already know are the ones that are going to do well, okay? All right, and then we are not going to be doing this one during a live session. That's going to be probably the next one where we'll talk about it a little more. But make sure that next time when we do have a live session, to be able to listen and wait for the live session to allow you to talk. You will all currently, when you start a live session, you're going to be muted. Rules are the same as in class. We must listen, take turns speaking. Behavior rules apply, same as before. If you act a certain way, I promise you I will write you up. And all of them, I can record them. So be aware that you are being recorded and your behavior is being recorded, okay? All right, so we're also gonna move into not only court cases and the amendments, but we're gonna talk about this term called selective incorporation, or sometimes it's referred to as incorporation doctrine, okay? Now, if you guys were here with me, I would ask you, do you guys know what to be incorporated is, or do you know what the word doctrine means? Because those two play a lot into it. Doctrine is basically kind of like a rule, a law, a way of doing things, okay? And then to incorporate something, you're saying, I'm going to add this in with this. I'm going to include this with something else, okay? So first thing we're going to talk about is this idea of what selective incorporation is, because it plays a lot into these court cases and how they relate directly to the different amendments. Okay, so, whoa, I'm blue. The 14th Amendment of the Constitution, I actually read this to you guys in the last video. I'm going to go through it again because I want you guys to pay attention to some specific pieces. Clauses you should know, 3 of them are sitting right here in this little bitty paragraph, okay? It says all persons born or naturalized. Okay, so anybody in the United States, if you were born here, so you're a citizen, right? We've talked about how you're a citizen by way of birth. Or if you were naturalized, you went through the process in the United States and subject to jurisdiction thereof, remember the word jurisdiction, are citizens of the United States. If you're born here, naturalized here, you're a citizen. So that means everything that comes with citizenship belongs to you as well, okay? Whereas are citizens of the United States and of all the state wherein they reside. So if you're a citizen of the United States and you live in Louisiana, you're also going to be a Louisiana state citizen as well. So this is the 3 clauses, the 3 clauses that are super important because they all deal with these different court cases and the amendments. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So they can't make a law that takes away something that a citizen has because they're a citizen, okay? That's called the Privileges and Immunities Clause, okay? So they can't take things away from you, your rights, your liberties, if they're allowed by way of the Constitution. Remember Article 6, the Supremacy Clause. There's another clause you need to know. Article 6, the Supremacy Clause says this Constitution is the law of the land. A state can't make a law that takes something away that the Constitution says we have, okay? Nor shall any state deprive any person, so a state, okay, Louisiana, cannot take away life, liberty, or property without due process of law. Due process of law is something that's going to be within a couple of the amendments, especially the 6th Amendment, where it talks about the process that you have to go through concerning like a criminal trial. You know, 1, you need to have read your rights. 2, you need to be able to have an attorney. 3, you need to be able to have a fair and speedy trial. You need to be able to have a jury of your peers. There's all these things that are supposed to happen, and that is called due process of law. Okay, this is called the Due Process Clause. It's in the 14th Amendment. And then the last one, nor deny, so no state shall deny any person, so no state can take away or deny me within its jurisdiction the equal protection of the law. I have protection under the law, okay? They cannot take that away from me, okay? And that's called the Equal Protection Clause. So y'all, just in those last couple of minutes, I talked about 4 clauses you need to know. You need to know Supremacy Clause, Article 6. You need to know the Privileges and Immunities Clause of the 14th Amendment, the Due Process Clause of the 14th Amendment, and the Equal Protection Clause of the 14th Amendment. All of those relate back to every one of these cases we're going to talk about in some way, shape, or form. Okay, so incorporation doctrine, all it is a constitutional law or rule through which the first 10 amendments, so first 10 from freedom of speech down to states' rights, the first 10 amendments of the United States Constitution are made applicable to the states. So here's what's interesting. When the Bill of Rights were made, a lot of the states were like, we don't need to do that. That's not, no, we don't have to worry about that. So what's going to happen is people are like, wait, this state is taking away my rights. This state is not doing what it's supposed to do. It's infringing on my rights, or it's not giving me due process or something like that. And what's going to happen is the United States Constitution is supposed to be supreme, and the states were kind of ignoring that. Okay, so that's where incorporation doctrine is going to happen. It basically says, no states, you have to do this stuff. Okay, are made applicable to the states through the Due Process Clause. So going back real quick, Due Process Clause is right there in red. Nor shall any state deprive any person of life, liberty, or property without due process. So they can't take away my stuff unless they give me due process of law. Okay, of the 14th Amendment. Now, what's going to happen is eventually there's going to be more and more and more of this, what's called incorporation, in which they say, no states, you have to do this too. So after the passage of the 14th Amendment, the Supreme Court is going to use this term called incorporation. They like to use the term selective incorporation, meaning they take little pieces of amendments and go, nope, states, you have to do this little piece. This little piece pertains to you, states. This little piece pertains to you. The Supreme Court would incorporate certain parts of different amendments rather than incorporating the entire amendment. Okay, so they choose They selectively pick pieces of the amendments that they say no states. You got to do that. So I gave y'all a list right there of incorporated amendments. The First Amendment is completely incorporated. Let's see, the Second Amendment is completely incorporated, and the Fourth Amendment is completely incorporated. Okay, we've talked about those in first semester, and we talked about those last class. The partial incorporation means they took pieces of these amendments and said, states, you have to do this, you have to abide by this. So the Fifth Amendment, the right to indictment means a formal accusation. So that's when, if you ever hear, and he's been indicted of, that means he's been charged with something. Indictment by the grand jury has not been incorporated. So you don't have to have a grand jury, basically. That's all that means. And grand jury is 12 people plus 2 alternates. The Sixth Amendment has been partially incorporated. The right to a jury selected from residents of a crime location has not been incorporated. So that means you don't have to necessarily have a jury from where the crime happened. That's, if you've ever heard of the change of venue, that is allowed. Change of venue just means you can move your case somewhere where people don't know about the crime. The Eighth Amendment, partial incorporation, prohibition against excessive fines has not been incorporated. That one is actually something that came up last year, I believe. I believe it was, I don't remember the state, but it was versus TIMBS, in which this may have been incorporated. I'll have to check up on it. In which the state basically seized a man's like vehicle as part of his fine for a crime or something. I'll have to look it up exactly. It is a Supreme Court case though. No, you don't need to know that one. Okay, no incorporation. Third Amendment, there's no incorporation about quartering of soldiers. Seventh Amendment, which we've talked about before, there's no incorporation of that. Ninth Amendment, no incorporation. 10th Amendment, no incorporation. Okay. All right. So within the Bill of Rights, remember, the Bill of Rights is a restriction of what things they can't take from us. Okay, it's our protection. So it's telling them you can't take these things away. All right, and they all start with Congress shall make no law, blah 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 blah. Okay, so here are some of the very first cases that succeeded with incorporation. Barron versus Baltimore. This is actually a case that you used to have to know, but now it would just be a comparison case. Happened in 1833, and it limits the reach of the Bill of Rights to the national government. The Supreme Court reasoned that the framers, so our dead guys, pretend we're in classroom, our dead guys, the framers of the Constitution did not intend the Bill of Rights to extend to the states. So Barron versus Baltimore almost says, wait, we can't incorporate, we can't do that. Gitlow versus New York, which is almost 100 years later, the court is going to kind of go back on that. And remember, courts change, the people in the court changes, and the ideals of those courts change, the politics of those courts change. The court voted to uphold the constitutionality of a law called the New York's Criminal Anarchy Statute of 1902, which prohibited advocating violent overthrows of the government, okay? So basically it's saying that can exist. It becomes the first case to mention this idea of incorporating, and in this case, it's incorporating the part of the Fifth Amendment. Neer versus Minnesota in 1931, so just a couple years later after Gitlow versus New York, the Supreme Court is going to basically say that the First Amendment doctrine opposing prior restraint. Prior restraint is basically kind of editing yourself concerning your free speech, saying maybe we shouldn't do the censoring and things like that, and reaffirmed the emerging view that the 14th Amendment incorporated the First Amendment to the states, meaning the states have to abide by it, and becomes the first to use incorporation doctrine. So the first one that really uses it is Neer versus Minnesota, which is in 1931. So not too long ago is when incorporation started. Sounds like a long time to you guys, but 1931 is a blink in history. Most cases now do go through some form of incorporation doctrine through the 14th Amendment and find ways to restrict your state and local governments from the removal of your rights. So incorporation is a good thing, okay? It allows you to keep rights that should be protected by way of the federal government, and it basically says state government also has to protect those rights. All right, I'm not going to show you guys this. Maybe I will. No, I won't. Okay. This is a 60-second kind of recap of incorporation doctrine. These two guys are like Miss Hitchcock, except they're dudes. Okay, they're awesome. They're usually called like the two social studies guys or the two AP guys. They run something called My Citizen U. It's a YouTube channel. They have tons of stuff that can help you on there. They also they do something called Cram for the Exam, which is going to be May 9th this year. I want to have a watch party with you guys on May 9th for this. We will talk about it in one of our MS Teams meetings about how that's going to work, because it's actually one of the more helpful pieces of the end of this course. They kind of literally help you cram for the upcoming exam, which would be that Monday. Okay, this again, it does go. It's 60 seconds of incorporation doctrine. Okay, and they're kind of weird, but they're super knowledgeable. Okay, so let's talk about some examples of incorporation. I chose one it's one of the ones we used to have to teach you guys. Now it's a comparison case, but it's called the slaughterhouse cases, which means there are multiple cases. 1873, it is dealing with literal slaughterhouses where you take your pigs and your cows and they get slaughtered and then turn into all the tasty things that we eat. There's actually 3 similar cases that are going to happen in New Orleans. The government is going to take over the slaughterhouses because they said there's environmental and health issues going on there, which means they're probably not treating the meat well, or it was kind of icky meat and they weren't being sanitary and things like that, which would be dealing with a Fourth Amendment issue, which would be seizing things without necessarily a cause or a warrant to seize things. And the government's not supposed to do that. The decision is going to be a 14th Amendment protection, so incorporation of privileges and immunities of citizenship of the United States, and it's not the states can't do that. Okay, so in this case, the slaughterhouses will win out, and the state has to basically deal. Gitlow versus New York, we already talked about that one. It is an easy comparison case and deals with the incorporation doctrine. It is the first time where there is the talk of incorporating the First Amendment, which is going to reverse Barron versus Baltimore from before. Now, what's interesting is it basically says that technically, if you want to be an anarchist and start a group of people, as long as you do it lawfully, you can plan to overthrow the government, but you got to do it lawfully. Kind of weird, right? Okay, so let's talk civil liberties, civil rights, remembering what the difference is in the two, because I've been talking about them now for a couple classes. Just want to make sure we know. Civil liberties are freedoms, okay? What we get to do. Think of it that way. Civil rights are what the government can't take from us. Okay, so our protections are our rights, our freedoms are our liberties. Okay, kind of think of them that way. Civil rights is, like I said, we usually think about African American civil rights, but that's what we talked about the last class. Okay, civil liberties are the things that you are allowed to do, in which those rights are your protections for. Okay. So let's talk about the First Amendment. We haven't talked about it yet. We've gone over it, but not really talked about the intricacies of this particular amendment. It is dealing with 5 specific things: freedom of press, freedom of religion, freedom of assembly, freedom of petition, and freedom of speech. Okay. Today I'm going to start with freedom of religion. Bet you thought I was going to start with freedom of speech. So your religious liberties are going to start from our beginnings. Remember, people came here for that particular thing. They wanted to have religious freedom. They did not want to have government-sponsored churches. So that's why religion is in our top 5 rights within the Bill of Rights. The First Amendment contains 2 fundamental guarantees of your religious freedom. One of them is called, here's some more clauses, guys, the Establishment Clause, which basically intends to prevent the government from involving itself in religion. So if you've ever heard separation of church and state, it really comes from the Establishment Clause and also a letter that Thomas Jefferson wrote, where he actually discusses separating church and state. And then you have the Free Exercise Clause, which its intent is to prevent the government, prevent the big guys from interfering with how you practice your religion. Okay, so that gets kind of weird because every year I teach this, some kid is always like, so that means sacrifice, human sacrifice is allowed. No, there are limits to the practicing of religion. However, there are allowances for certain religions to allow certain types of drug use, especially out west. There's a few Native American tribes and cultures that they actually use things like a drug called peyote within their religious ceremonies. So sometimes it's actually okay, and there are court cases that back that. Both of these protections have been extended to the Due Process Clause of the 14th Amendment. Again, incorporation. So the Establishment Clause is interesting. It basically says, Congress shall make no law respecting an establishment of religion. So that means Congress can't say anything about religion. Now, can a congressman say he is Christian and he believes in God? Yes. But he cannot do anything concerning the establishment of that religion or the practice of that religion. So when you're reading it, clearly you should see that it's prohibiting an establishment of a national church. Why did they do that? Because the C of E, y'all, the Church of England, it all comes down to somebody needed a divorce. The Catholic Church wouldn't allow divorce. Henry VIII was like, I need a new wife because I need one to finally give me a son. And then he gets a divorce. And when he does that, he creates the Church of England. Okay. And a lot of you guys may have heard of the Anglican Church. That's what that comes from. So, what else was meant by this? Thomas Jefferson, he is going to be the one that argues this the most, argued that the First Amendment created a wall of separation. Okay. He has actually written those words down, a wall of separation between church and state. So now you know where anytime you hear, well, there's a separation between church and state, people are referring to one of two things, either the Establishment Clause or something that Thomas Jefferson said, which would prohibit not only favoritism, but any support for a religion at all. So he basically was like, government needs to stay the heck out of religion, period. No person in government should talk about which religion is better than another religion or what religion they are. He felt that you should stay completely out of it if you are in the public eye. And this is a quote from him. It does me no injury for my neighbor to say there are 20 gods or no God. It neither picks my pocket nor breaks my leg. So basically, his idea was, if you are a politician, shut up about religion. Okay? That's basically the idea of the Establishment Clause. If you're in politics, religion should not be a part of your politicking. All right, so with the Establishment Clause, as we move through history, there are going to be some things that come up about it. One of them is something about what is called aid to parochial schools. If you don't know what a parochial school is, go look it up. The name of this particular case is Lemon versus Kurtzman. Again, this is a comparison case that I used to have as a required case, okay? This one is dealing directly with the Establishment Clause, and the Supreme Court is going to declare that any aid to church-related schools, so this is, now you know what parochial means, any aid to church-related schools has to meet what is called the Lemon Test. So if you ever hear something called the Lemon Test, they're referring to Lemon versus Kurtzman by way of the Supreme Court. So basically what's going to happen is you have Catholic schools or religious schools in general, and they're going to say, but, you know, we might need funding, we might need help or something for, you know, school books. You know, we need some new algebra books or something like that. So the Supreme Court is going to create this test, the Lemon Test, so to make sure that everything is lawful and the Establishment Clause is respected. So whatever the school is asking for, it has to have what is called a secular purpose, which means no religion involved. Algebra books. The primary effect of their request should not be to advance or inhibit religion. It can have no religious purpose. And it must not excessively entangle government with religion. Okay? So like if Parkview Baptist was like, government, we need some help with funding for new algebra books. If we look at those three things, that passes the Lemon Test. Okay? So that's okay. So the 1980s though, kind of, those lines kind of got blurred. And a lot of it had to do with, we had a movement into a more religious Republican political party. And some stuff was kind of allowed, and that wall of separation was kind of lowered with a lot of things that were dealt with. You know, for instance, there's a law that says we're not supposed to have school prayer, which we're going to talk about in just a second. And a lot of schools were still being allowed to do that, and nobody was getting penalized for it. All right, so let's talk about some policy or laws, acts, statutes that come out of some of this stuff. So a law was passed in 1984 that says public schools cannot deny access to their facilities for religious groups to use. So for instance, if a religious school, say like, MBS right behind the school, if they were like, we want to have 8th grade graduation on your football field, we can't say, no, you can't do that because you're a religious school. It's not for a religious purpose. If they wanted to play football, we can say, hey, yeah, you can pay us X number of dollars and you can totally use our football field. So we can't, as long as there's not a religious purpose involved, it's okay for us to allow religious schools to use non-religious facilities, basically. State laws, the key to this is that state laws which interfere with religious practices, including drug use, must be found to have compelling state interest, okay? So like I said, there are some places where it is completely allowed for a religious ceremony to include certain types of drugs, like peyote, if you are of that particular religion, okay? Kind of weird, I know. All right, so when we're talking about the Establishment Clause, we also have a couple other cases. So this last one that we talked about, Lemon versus Kurtzman, it is a comparison case. Again, a lot of these cases I'm talking to you guys about, one, because it shows you how the Establishment Clause works, how the 14th Amendment works, how incorporation doctrine works, but it's also keys to answering FRQs, okay? So Zellman versus Simmons-Harris. This is, again, one of those cool comparison cases. It's dealing with the Establishment Clause again. The Supreme Court is going to uphold or say it's okay for programs to provide some families, in this case, Cleveland, Ohio, with vouchers that could be used to pay tuition at religious schools. Y'all, we have this here. There are kids that if they're at an F or a D school, we usually refer to it as like school choice, where they can get access to other schools by way of scholarship. Like a voucher, basically saying we have X number, we have 5 spots. And for, say, underprivileged kids or kids that are coming from a D or F school. So we have that here in Baton Rouge as well. And this is basically saying that it is okay. And at the bottom, I have what Justice Tom Clark actually said about this. The place of religion in our society is an exalted one, achieved through a long tradition of reliance on the home, the church, and the inviolable citadel of the individual heart and mind. We have come to recognize through bitter experience that it is not within the power of the government to invade that citadel, whether its purpose or effect be to aid or oppose, to advance or retard. In the relationship between man and religion, the state is firmly committed to a position of neutrality. So right there, he is saying, we're staying out. It's okay. You can do that. All right. Here is a required case, you guys. Engel versus Vitale concerning, yes, you guessed it, the Establishment Clause. So I'm going to go through the whole case with you guys, the facts and what happened, because you guys need to know, again, required case, got to know it. Engel versus Vitale is going to happen in the year 1962. So that's when the verdict or the court, comes up with their majority opinion. Okay, so we're in New York. The New York State Board of Regents authorized a short voluntary prayer. Board of Regents, just so you know, we don't really have that here, is basically kind of like the school board. So the school board in New York authorized a short voluntary prayer for recitation at the start of each school day. Okay, so just so you know, in the 50s and 60s, that was completely normal. For every day you say your pledge and then you say a few words to God, and in this case, it is the Christian God. So Engel, who is going to be, that's the last name of a parent within the school district, argues that the saying a prayer violates the Establishment Clause of the First Amendment. So this is why it's good to know your rights and things like that, because you will then know when they're being violated by your state or local government. So the Establishment Clause of the First Amendment as applied to the states through the 14th Amendment, which is, again, incorporation. The New York Court of Appeals is going to reject those arguments. They're going to be like, no, no, no. So it's going to make its way up to the Supreme Court. Remember that process to get to the Supreme Court. You got a petition, you have your writ of certiorari, you have your rule of 4, you have your discuss list, all that stuff moving all the way up until you get to your actual Supreme Court. Well, this goes all the way through that process. So the question, the constitutional question, that's one of those things that I talk about a lot that you need to know about these cases, is what is the actual question? Why does the court need to, what are they trying to figure out? Does the reading of a non-denominational prayer, now non-denominational but Christian prayer at the start of the school day violate the establishment of religion clause of the First Amendment. The Supreme Court is going to rule that state-sponsored prayer in public schools was an unconstitutional violation of the Establishment Clause. You cannot have prayer basically required in school, okay? Now, everybody, every time I teach this, people are like, but wait, do this. Y'all, we have a moment of silence. What you do in that moment of silence is up to you. If you want to pick your nose during that moment of silence, pick away. If you want to pray, pray. If you want to think about, you know, what kind of cool things am I going to do today? If you want to think about how much you hate being at school, if you want, any of those things can be done. There's nothing that says it has to be prayer. So that's how it's been gotten away with, kind of, because we no longer call it prayer, we call it a moment of silence. And it's your moment, not the school's moment. Okay, so they're not violating the Establishment Clause with that. So Establishment Clause concerning Engel versus Vitale, school prayer is not allowed. Now, can students start the prayer and other students join in and then teachers join in? Yes, that's different because it's not school sponsored. All right. Second, remember there's two cases we're going over today that are required. Second one is Wisconsin versus Yoder. This one's dealing with that other clause called the free exercise clause, meaning you can exercise, you know, your religion as needed. So the people involved are Jonas Yoder and Wallace Miller. Both of these are members of what's called the Old Order Amish religion and the conservative Amish Mennonite church. So they're Amish, okay? If y'all don't know what Amish is, you've probably watched the weird reality stuff on the Amish. But Amish are basically, they're super duper fundamentalist Christians. They don't believe in the use of electricity. They make their own, you know, furniture. They build their own houses. When you get married, if you're a man, you grow a beard. They make their own clothes, all kinds of stuff. So they're very interesting people, if anything. I stalked some Amish people once in Delaware. They amaze me. So anyway, off topic. So basically, they are going to be prosecuted under a Wisconsin law. So Amish in Wisconsin are prosecuted under a law that required all children to attend public schools until the age of 16. Just so y'all know, you have this here in Louisiana. It's called compulsory education, meaning you got to do it. It's mandated. The three parents involved refused to send their children to schools after the 8th grade. In Amish communities, 8th grade's the end. That's where you stop, because after 8th grade, you go to work. You go to work as a farm, as a field hand, as a shoemaker, as a seamstress. You go to work, okay? Arguing that high school attendance was contrary to their religious beliefs. So they basically brought out their religion. They said, we go to school until this point. After this point, our religion doesn't require that we continue that kind of education. So, constitutional question. Did the state of Wisconsin's requirement, their compulsory education requirement that all parents send their children to school until at least the age of 16, violate the First Amendment by criminalizing the conduct of the parents? Y'all have heard of truancy, right? Sometimes if you're continuously truant, your parents then get in trouble, and you know they can be fined and have court appearances and things like that. Who refuse to send their children to school for religious reasons. The court is going to find, meaning their majority opinion is that the values and programs of secondary school were in sharp conflict with the fundamental mode of life mandated by the Amish community. So in this case, you guys, Amish is going to overtake the school system, okay? So, and that an additional 1 or 2 years of high school would not produce any benefits of public education cited by Wisconsin to justify the law. So guess what, you guys? If you are Amish, you get to leave school after 8th grade according to your religion, because the free exercise clause protects that for you. Now, if you're a Christian and you're just like, I don't want to go to school, that doesn't count, okay? So free exercise clause. So first, remember we did a bunch of cases with the Establishment Clause. Now we're going to hit a bunch that have the free exercise clause. Engel versus Vitale, that's the Establishment Clause. Free exercise, that's Wisconsin versus Yoder. This one is going to be dealing with the limits on free exercise. It's called Reynolds versus the United States from 1879, a long time ago. The issue is concerning something called polygamy. Okay, polygamy is where a male can marry more than one wife. Okay, duty to marry many women. A lot of people are going to put this together with Mormons. Okay, and this was something specific to that particular religious group. Not so much today. There are specific groups within that community that do still, they're polygamists. You might have watched the show Sister Wives. That kind of shows polygamy in action in modern day, but technically it is not. It's illegal. Polygamy is illegal. So what we have is the Supreme Court is going to make an important distinction between religious beliefs and religious practices. The court cannot restrict what a person believes. So I can't tell you, you can't believe in polygamy. Okay, I can't do that. However, the court can do some other things concerning that. Society has a right to legislate against religious activities that violate the law of the land. Okay, so the Supreme Court is going to rule against the polygamists, arguing that permitting polygamy would make the professed doctrines of religious belief superior to basically saying polygamy is okay, is allowing religious belief to be superior to the law of the land, which is the Constitution, and in effect to permit every citizen to become a maw unto himself. Okay, so in this case, religion does not overtake the states. Okay, the states overtake religion in this particular sense. So polygamy is going to be illegal, outlawed, and continue to be illegal and outlawed. But yeah, so this is a kind of interesting comparison case about something a lot of people don't really know about. All right, you guys, I'm done. I'm going to post this. I hope you guys pay attention, take notes. Remember, it is an open note test. Use it to your advantage. There's only 3 units it's dealing with: first unit, second unit, third unit. I'm going over the third unit right now. Take some notes, all right? I want you guys to do well on this. I know you can do well on this, but you've got to put in the work because I can't take the test. I can't, and I can't go to each one of your houses and help you because then you would be, found out for cheating. That's not good. So y'all, take notes. Look over what I'm saying. Read through that book, y'all. You only have to know a little chunk of the book now as opposed to the whole book. All right? I want y'all to do well, but you have to have that inside drive that keeps you going through this. All right? Peace out, guys.